Pleasure to welcome you to our CLE this afternoon. We are delighted to have the opportunity to put on this program for you as a part of our business advising program. The business advising program focuses on providing our students with the foundational skills and knowledge that they need to be client ready when they graduate to advise small and medium-sized businesses that make up the bulk of our economy here in the United States. So this is just a wonderful opportunity that we're going to get to learn about the UCC and digital assets. So now I'd like to invite up Professor Christian Johnson, our Commonwealth Professor of Business Advising, to make the further introductions.
Thank you very much. It's my pleasure to be here. This is really exciting tonight. We're talking about digital assets and cryptocurrency, a whole new area, and there are so many different kinds of law that have really yet to be defined and explored. And what's really exciting about tonight is we have Sandra Rocks, who's of counsel for Cleary Gottlieb in New York, and we have Kathryn Witchger, who's also an associate from Cleary Gottlieb. And one thing, if you understand the pecking order in New York, is that when new areas of law come out, Cleary is the place that clients go to pay them, to learn the issues, and to sort through things, and to really develop the framework and template for what's going on. And these two are on the cutting edge of what we call fintech. We'll let them explain what we mean by these different terms, and they'll give you an introduction and to all of the great things that are going on. We're grateful to both of them. They've taken out a large amount of time for us to come down. They just met with our students in a roundtable conversation about being a transactional lawyer, and we really appreciate their time and energy for coming here today. So I'm going to go ahead and turn the time over to them.
Thank you, Professor Johnson. I just wanted to tell you a personal tidbit because you go way back with my former work spouse, Seth Grosshandler. You know he is, just to make us all feel inadequate, he is composing classical music and having it performed in various locations.
Around New York City.
Right.
Crazy.
Now, I'm kind of a T Swift girl, but, you know, I do go, I show up. Well, I love her too. And Lady Gaga. Okay. So anyway, but we're not going to talk about those things, although we should do a CLE that works in some of their songs. I think that would be really great. What we're going to talk about is what you see up on the screen, and we're going to try and stick to the hour because we have too much material. We're going to talk a little bit about backing up and looking what is a digital asset? What are we talking about? Spent a little time talking about the existing Uniform Commercial Code, which, as you know, is a body of law that is adopted on the state level, usually without much variation, and governs various transactions in a wide variety of assets. And the question is, where do digital assets fit into that? And then some overview, a particular shout out for Article 8, my personal favorite, investment property, the new legislation, some highlights of litigation that's been happening that you've probably read about in the newspaper, and then, because it relates to that, a little short, very short discussion of what happens if my digital asset custodian goes bust. So with that, Kathryn, I was wondering, could you spend a little time telling us what is a digital asset?
Sandy is so nice. She gave me a full 10 minutes to nerd out about this topic. I love financial technology, in particular cryptocurrency, because it has created a really interesting way to analyze laws that we all know and love, but in a new manner. And to do that, you really need to understand what's happening with the technology. So we all know that in our traditional financial system, generally, transactions move through a centralized authority, like a bank, that approve transactions and keep a ledger that says where money has moved to and whether that was a valid transaction and double check all of this good stuff. Well, we have now moved to a distributed ledger system when it comes to digital assets. So what is a distributed ledger? It's things like blockchain is a type of distributed ledger. It's a record of a transaction that is maintained on a peer-by-peer basis. What does that mean? All of the different nodes on a blockchain have access to the exact same record. It's like a ledger lines on a ledger record, and they all have access to that record. And they keep that record up to date using a consensus mechanism, which is a way to determine what transactions are valid without using a central authority. So let's do a little example here. If I want to send a digital asset to Sandy, what I'm going to do is I'm going to log online and I'm going to go into my wallet, and using the private key in my wallet, I'm going to say, hey, I want to send money to Sandy. That transaction will be sent as a block to the network. And then certain nodes on the network that are given the role of validating transactions there's a couple of methods to validate transactions, but those nodes that are given that job then validate or decide the transaction isn't valid. And if it is found valid, they approve it and add that block to the ledger line. So pretty simple. And then the digital asset would then be shown to move from me to Sandy.
And I need my own private key.
Yeah.
Because a wallet isn't like a wallet in my pocket, apparently.
Yeah, we'll get to that too. We'll go through a taxonomy of common issues that when folks are looking at these, that can kind of change the way they analyze it under law if you're not thinking about it from a really technological perspective. Those what I just described are the three fundamental characteristics of a blockchain. It's a distributed ledger that uses cryptography, a public key that is known by the world, and a private key that is known only by you to access your assets. And there's a consensus mechanism whereby validators on the chain decide whether transactions are valid or not. Ooh! Ah! And there was light. Okay, there we go. So if we've got a bunch of people deciding what transactions are valid and what is not, what happens if there's a disagreement as to what transactions are valid and which ones are not? Most of the time, that's decided by a majority of nodes and they say yes or no, but sometimes it can lead to a fork. And what are the situations where it leads to a fork? Let's talk about soft forks first. This is usually one example, a good example of this is when there has been an update to the consensus mechanism. So that's the mechanism that the validators use to decide whether a transaction is valid. And let's say that they make those rules more strict. So a transaction is only valid if it does A and B, that's the normal rule, plus C. So by adding C, the non-updated nodes, the ones that haven't downloaded this new software, would say, okay, A and B are all valid. And the updated nodes would say, okay, it's not valid unless it has A, B, and C. So this will resolve, and the reason why it's called a soft fork is because it will resolve when all of the non-updated nodes are updated and everyone starts to use that A plus B plus C formula. There we go. And then a hard fork is a permanent divergence in the chain. So let's say instead of upgrading one portion of the consensus mechanism, let's say you completely change the consensus mechanism, let's say from proof of work to proof of stake, like Ethereum did. We'll go into what those words mean in a minute. But if you change the consensus mechanism completely, there's going to be non-updated nodes that continue along their pathway validating transactions using that consensus mechanism, old one, and new updated nodes that are using a new method, and that creates a permanent fork. Why does this matter for us? Well, when you're contracting around these issues, you have to think about what happens when there's a fork. Which chain is now the valid chain, and how do we handle that? And a lot of digital asset custodians think about this differently, but we won't get into too much detail there. There's another technological term that's thrown around. It's called airdrop. It's a lot less cool than it sounds. It's usually a marketing tactic. If I have a digital asset and Sandy's starting a digital asset and she wants to, and I've got a really popular digital asset, Sandy might say, okay, Kathryn, let me distribute some of my digital asset along with yours for free to your users to get them, to start to know my digital asset. That would be an example of an airdrop. Another example is, I say to my users, hey, if you post about me on Instagram, I will give you an extra token. Another example of an airdrop. So let's talk also about some digital asset taxonomy, because it's helpful to know. I use the term digital asset. You'll hear lots of folks use different terms, but it's really important to be clear on what term you're using if you're contracting with these, right? So one category is cryptocurrencies. Those are your Bitcoins, those are your Ethers. Those are not backed by government fiat, and they solely exist on a distributed ledger or a blockchain.
They're native to that.
Yes, they're native to that chain. That's a way that, yeah, good lingo. Stable coins. Stable coins are in some way linked to another asset. Typically, the most popular stable coins are those that are linked one-to-one with a underlying currency. But it doesn't necessarily need to be a currency. It could be linked one-to-one with a pool of maybe like a treasuries and securities. And so generally the person who issues that will hold the assets underlying that digital asset in a custody and be able to trade it in and out. So if it's if it's one USD for one stable coin, then the digital asset issuer that issues that will hold the one USD and give you one stable coin, and then we'll be able to swap it back at the end. CBDCs are central bank digital currencies. These are newly developed, and they're in a couple countries, but they haven't really taken root yet in many countries. But they're backed. The key difference between these and cryptocurrencies is that they're backed by the full faith and credit of a government or central bank. But they still operate on a blockchain, and there's lots of possible architectures that I could talk for a long time about. Utility tokens. Utility tokens provide some right to a good or service. So if I have a file coin, I have a right to access file space on a computer using that file coin. So it ties the digital asset to some sort of right. Another example of tying a digital asset to a right are tokenized financial instruments. These are just representations of things that we know and work with a lot in the world. Let's say like a security. I have a security. I can represent that with a digital asset, and it becomes a tokenized financial instrument. And finally, there are fun NFTs. These are completely unique type of digital asset. Each one is unique to itself. And I think the key thing to think about here in practice is NFTs often don't actually have the thing of value as part of what they are. And what I mean by that is, if it's the picture of the dog, the very famous one, it will have a link to the picture of the dog in it. But it is not itself the picture of the dog. So you got to take with a grain of salt what you're getting in terms of IP rights.
Yes, especially given the recent case with the Birkin bags. I think that's what they are. Birkin bags. The guy lost.
Yeah.
He made an NFT.
So sad.
Yeah. Crushed like a grape.
Yep.
All right.
So these are other key taxonomy. Do I have enough time to go through this slide?
I think it would be, yes, quickly.
Quickly, okay. So remember how I was saying when I send talking about sending a digital asset to another person, that's done through public-private key encryption. So when I send the digital asset to Sandy, I will encrypt that digital asset, that packet of information, using her public key. Her public key is tied to her private key. And
But you don't know my private
But I don't
key.
know her private key. I only know her public key. Everyone can know her public key. Right. And so when I encrypt using her public key, only her private key can then unlock that package of data and access that digital asset for transfer. Wallets are super important, but they're not what you think they are. They are not the ones in your pocket. They don't actually hold digital assets at all. Wallets just hold the private key that is used to transfer your digital assets. Your digital assets themselves, like we were discussing before, are just ledger lines on a ledger. But if you want to transfer that digital asset to somebody else, you need that private key to transfer, and that's what your wallet holds. So hot, cold storage. Hot storage means it's connected to the internet. Cold storage means it's not. It's on probably a little flip drive or something. Smart contracts, these are not contracts. They're not smart, exactly. They're algorithms. They're if-then statements. If XYZ happens, then it's basics of computing right there. And they were called smart contracts. And immediately, Vitalik, I think, was the one that invented it, and he immediately regretted it because it caused a lot of confusion in both the legal community and in the non-legal community. But they're not contracts at all. They're if-then statements. Permissioned or permissionless ledgers. This is really important. Remember, we were saying that there's a group of nodes that participates in a consensus mechanism to decide what transactions are valid. Well, if it's a permission system, then there are if it's a permissioned blockchain, then there are certain rules and only certain individuals or nodes can participate in that. If it's permissionless, then anyone can set up that node and to validate and run the specific software to participate in that. So your banks are going to be more likely using a permissioned system to ensure the integrity of the validation. Bitcoin, Ether are completely permissionless. Proof of work and proof of stake, I'll let you read those. It'll take me a little longer to explain and we're running out of time, but both of those are forms of consensus mechanisms. So those are the mechanisms by which you decide, your group of people on the decentralized ledger decide whether a transaction is valid. Those are two different types.
And there's a lot of movement towards proof of stake. And for those who care about environmental issues, my understanding is that proof of work burns up a lot of electric power,
Yep.
and proof of stake requires much less. Am I right?
Yes, you're
Thank
totally
you.
right. And DeFi is something that we're seeing. We're seeing a lot of, in the traditional finance space, we're seeing a lot of folks who work with derivatives and complex high finance contracts, moving into the blockchain, Bitcoin, digital asset space, and offering those services on a peer-to-peer basis. So DeFi kind of describes that large movement that's happening, and also, but specifically on a peer-to-peer basis. Rather than going to your Goldman Sachs of the world, you're just going to Joe down the street and saying, hey, well, through the internet, saying, hey, give me a loan, or hey, enter into this swap with me. So those are the basics.
Decentralized, and now, so that means that traditional finance is now TradFi.
TradFi instead of DeFi.
Yeah.
Okay. Well, Sandy, can you please tell us how we treat digital assets under the current UCC rules?
Thank you, Kathryn. I would be happy to talk for a few minutes about that. So, next slide, please. So as we mentioned, the Uniform Commercial Code covers a lot, as enacted in each state, covers a lot of transactions in personal property. We're not talking about real estate. It talks about goods, negotiable instruments, bank transfers, deposits, letters of credit, warehouse receipts, investment property, my personal favorite, and secured transactions in Article 9. And so if you're playing in the digital asset space, you're going to wonder, it's clearly not real estate, whether the Uniform Commercial Code covers it and how it does that. And how you start to think about it is you look at what category would digital assets fall into. There's for example, in Article 9, and of course don't forget Article 1, but Article 9, which governs many secured transactions and many sales of various assets, you look at the definitions there. The UCC has a long list of definitions, I think like 13 or something like that. Most of them are pretty fixed in terms of parameters. There is one, which is under Article 8 of the UCC that we'll talk about a little later, that has some inherent flexibility that parties take advantage of, which we'll mention. So what could these digital assets be? Well, it depends on what they are, of course. Some are native, like Kathryn was saying with Bitcoin. Some are representations or manners of accessing an underlying asset. Like you could have a digital asset that evidences a right to a certain amount of gold, for example. Those are out there. Or certain stable coins or certain other tokens represent certain underlying rights, unlike Bitcoin, which is just in its native state. So what could it be? Well, depending on what its attributes are, could be a general intangible, which many of you may have heard of. It's kind of the garbage bin of the UCC. If it's not something else, it'll be a general intangible. Could be investment property. I gave you a spoiler alert. Could be money, depending on its attributes. Could be an account, which is a right to payment. Could be a deposit account, right, maintained at a bank, depends. Could be electronic document of title, like to Pax Gold in my view, is something similar to that. Could be electronic chattel paper, which is like an auto loan that's done in electronic form, but these are digital. The applicable characterization, though, what bucket you fall into, is going to tell you how annoying it is for you to get a perfected security interest in that asset, or whether you can ever acquire rights in that asset free of adverse claims of third parties, right? Which is very important. So we went through these. We're just laying them out there so you have the definitions handy, which will help you slot in if you ever go home and you're kind of like wondering, well, what do I do tonight? I think I'd like to think about digital assets and what UCC category they file into. So, right. So let's take a few and just say, hey, if it's one of these things, then what? What do you think?
Oh, great. Let's start with the garbage bin, because a lot of digital assets fall into this one. Ether kind of usually is generally falls into this one. So if you're a general intangible, if your digital asset is a general intangible, you are going to need to perfect it by filing a UCC financing statement in the jurisdiction of the debtor. And that becomes a little bit tricky. And most people in the digital asset space don't think, hey, I need to perfect my security interest in a digital asset. They think, I hold it, I have the private key, therefore I am perfected. That is not actually the case. And so we see in a lot of the recent bankruptcies, a lot of issues with this. There's a lot of negotiation happening in the background, and some of it is coming to the forefront in actual cases decided by the bankruptcy judges regarding this issue of when a general intangible is perfected and when a digital asset, what category it's in, You have priority if you are the first to file. Many people forget this with their digital assets and they do not file at all. So if somebody later in time comes along and files, they are now have priority. And there are no UCC rules, unfortunately, addressing whether you take the asset free of adverse claims. So if I transfer it to Sandy, and I shouldn't have transferred it to Sandy, maybe I actually owed it to somebody else, or it wasn't actually my asset to transfer, Sandy now has it, and she's like, well, Kathryn's very reliable.
Possession is 9/10 of the law.
Yeah, Kathryn's reliable. It's no big deal. She has no safe harbor. She has no protection. If the folks that I owe that digital asset to find out, they can go to Sandy to get it back.
And by the way, footnote on this, I was in a great program the other day at the ABA where one of the folks was saying, yeah, we get a lot of subpoenas because people think that you can't trace and that you don't know where these assets went, but they do know where these assets went. It's not so hard.
And you all know it's not so hard because it's all on a publicly available ledger distributed to every single node on the chain. So we all know, based on the technology, that it's very easy to trace. Okay, money. So spoiler alert, Bitcoin could be considered money. Why would we think that? Well, the definition of money in the UCC includes a medium of exchange authorized or adopted by a government. And unfortunately, the Central African Republic and El Salvador said, hey, Bitcoin is our legal currency now. So if you're working with Bitcoin, you may not have a great way to perfect your security interest, because perfecting a security interest in money requires tangible possession of that money. And this is an ongoing issue. Some folks think that's not actually required. Some folks think it is. And I don't think the permanent editorial board has come out one way or another.
Someone was trying to be helpful and suggested that possession could be somewhat malleable or something, or that because the drafters had a certain kind of money in mind, they never intended it to embrace Bitcoin, and therefore it would stay in the general intangible category and you could perfect by filing. That did not get traction.
No, it did not get traction. So this is an ongoing area. We'll see this come up in hopefully cases soon. I'm very excited to see what happens. A transferee of money takes free of a security interest as long as it does not act in collusion with the debtor. So that's at least a helpful thing. But do you have possession? Because you need to have physical possession. Makes it a little trickier. Few examples of investment property. Your digital asset could be investment property. You can perfect your security interest in investment property by control, and control has priority over any pesky financing statements. So this might be, if you can get it to fit in this category of investment property, you might be golden, because control is a lot easier to come by than filing a financing statement, which can be a pain. You also take free of adverse claims from the point in time that it becomes investment property, which gives you some protection, maybe not full protection, but some protection. Well, Sandy, we talked a lot about investment property, and we love investment property. Can you tell us about UCC Article 8 in digital assets?
And why it's so special? Thank you,
Yes.
Kathryn. I would love to. So remember I told you the categories are generally have hard borders on them in the definitions in the UCC, except for a little bit of malleability in one category, and that is the category of a subspecies of investment property. Investment property embraces securities. There's a lot of litigation out there right now about digital assets being securities or not for federal purposes. That doesn't determine it for UCC purposes, but you could be a security, you could be investment property includes securities accounts, and it includes financial assets that are credited to securities accounts. What is a financial asset? Well, we bolded the one we care about here because securities we can skip over. Medium for investment, that's going to have a sunset provision that we'll talk about later. But any property that's held by a securities intermediary for another person in a securities account, if the securities intermediary and that other person have agreed that they're going to treat it as a financial asset. It is self-referential. It pulls it in because you said so. If you're a securities intermediary, defined here, which does not have to be a regulated entity, any person who maintains securities accounts, right, and is acting in that capacity. And securities account is defined as an account to which a financial asset is or may be credited. How many people see that's a circle? Yes, it is circular. It is completely circular. Why is it circular? I'll give you one good answer. Because the drafters wanted it that way. Why did they want it that way? They wanted Article 8 and the holding through securities accounts to be able to receive in new kinds of property, whatever it might be. We couldn't think of it at the time when we worked on revising Article 8, but this was a gatekeeping term, and it was very flexible. Medium neutral has nothing to say about the quality of the asset. It's just about whether it would make sense to let the securities intermediary and their customer agree to treat it as a financial asset. Now, what do you think about making sense of that?
Oh, me, sorry.
Yeah.
Well, we have to turn to the duties of a securities intermediary. And there are 5 duties in Part 5 of the, of the Article 8 of the UCC discussing those duties. 3 of them very clearly apply to digital assets. The first one is that a securities intermediary has to hold an amount corresponding to the underlying entitlement of their customer. Well, that makes sense. If somebody's custodying their securities with me, their digital assets with me, I should hold the digital assets there. I should hold an amount so I can pay them back when they want it back. The second one is the intermediary should comply with the must be able to comply with the customer's orders to transfer the digital asset. Well, that one also makes sense. If I'm custodying it, if I'm a digital asset custodian and I'm custodying it, yeah, sure, I can send it to somebody else if they want that to happen. The last one is very similar, to change the way it's being held. If they want me to send it to their personal wallet and no longer hold it at me, the custodian, that's also fine. That is something that it would make sense to do as a securities intermediary holding digital assets. There are 2 that are a little bit weird. The first one are the intermediary has to, if the issuer of the financial asset has any distributions on that financial asset or proceeds on that financial asset. So if we're thinking about securities, that's like there's a dividend being paid on the security. So the rule is your custodian should pass that on to you. Like that should be something that they do. And that's one of the Part 5 duties here. Well, in the digital asset space, we can go back to our concept of forks or maybe even airdrops, right? It makes sense that the custodian of the digital asset would pass on what's been airdropped to the person who is the owner of that token. So maybe we can work with that one. The second one is that they have to the intermediary should follow the customer's orders when it comes to voting in typical securities. That's like, oh, let's vote for, the board. In the context of digital assets, we don't really have that. But what we do have is native digital assets often include, each digital asset often includes a right to vote on governance mechanisms of the underlying blockchain. So maybe we can look at that as a right that the securities intermediary is exercising on behalf of its customers. So maybe it does make sense in digital asset context. But we all know that digital assets are all different and they have many different components, and some of these might not be applicable for each digital asset. The recent comments make clear that that's not necessarily a problem. If one or two don't fit, it's okay, as long as it generally makes sense to apply these duties.
And in real life, we've got clients who are trying to act as securities intermediaries of digital assets, most notably, and it's very public, Coinbase. They act as a securities intermediary holding Bitcoin and Ether. Do they hold Ether too?
They hold a lot of different things.
A lot of different things. And they want to act as a securities intermediary, and you will not be surprised to hear that when we help them analyze complying with these duties of a securities intermediary, there's a lot of language built in there as to how they are going to comply with the duties and disclaiming responsibility for a lot of stuff that they may not be able to handle. And it's all very creative and new, and also, don't forget, indemnities.
And nobody reads their user agreement, but if you read their user agreement, you'll see that and built in there. There are some limitations. We're going to skip this slide. Fun limitations on how it applies to digital assets, but you can read that at your leisure and then send us emails because we love talking about this topic if you couldn't tell.
Yes.
All right, Sandy, let's talk about the new legislation.
Let's. So for the first time in 40 years, I think it's 40 years, there's a new article of the Uniform Commercial Code. The Uniform Commercial Code has been amended over the year, most notably about 23 years ago, Article 9, all the security interest stuff was revamped. And in the 80s into the 90s, Article 8 on investment property was revamped. Article 6 is totally ignored, bulk sales, but bulk transfers. But anyway, now, first time in many, many years, the drafters got together. A big study group was put together. There were regulators, market participants, professors, private practitioners to think about what all this new technology meant for the Uniform Commercial Code as a whole, going through every single article and thinking about whether the new technology was suggesting that changes needed to be made to each article if that was needed. And one of the things that was quickly determined was yes, certainly some changes are needed internal to existing articles, but what was desperately needed was an overarching article dealing with certain aspects of digital assets. And so the study group flipped into a drafting group, and 2 years later, the Uniform Laws Commission approved the new article. Why? Why was a new article needed? Because what we said to you earlier is the market is acting like they can deal with digital assets in a way that doesn't comport with the commercial law. The commercial law characterization, as we said to you, many times treats digital assets as general intangibles because it doesn't fit in any other category, which means security interest, perfection requires filing. That means searching. There's no take-free rules, and the market's acting like this stuff is all negotiable, using that term loosely.
And it's not.
And it's not. The main parts of Article 12 are that it brings in new rules for what's called a controllable electronic record, which Kathryn will explain to you what it is. It brings in take-free rules, meaning you can acquire these things free of adverse claims if certain circumstances are met. It deals with particular types of tethered assets, digital assets that bring with it rights to payment from an underlying human or company. And new choice of law rules, which are so much fun, brings in revisions to the rules for money, of course, because we already saw we had a problem with Bitcoin. And then all the other amendments, all the other articles, including some tweaks to Article 8, but mostly to make it more welcoming to digital assets. All right. What are those controllable electronic
Yes.
records things?
So really happy that they drafted this so broadly. Controllable electronic record is an electronic record that can be subject to control. So electronic, having anything to do with electrical, digital, magnetic, wireless, really broad definition. And then a record, information that is stored in an electronic or other medium and is retrievable in perceivable form. That could cover so many things that have not yet been invented. And this was drafted this way to try and help us as attorneys not be faced with the same issues that we discussed at the beginning of this deck, where there was no really perfect home for these assets and as new assets. So, love that. They have to be subject to control. What is control? Now, this is where things get really tricky. Control has 4 kind of prongs. The person has to have the power to avail itself of substantially all of the benefit of the record, the power to prevent others from availing themselves of that, or to exclusive power to transfer control and to identify themselves as having these types of powers. So it's kind of a tricky definition, and it'd be hard to pinpoint where that is. But the reason it was done this way is to, again, look forward to a scenario in which there is a new type of asset that we've never heard of or thought of, and create a broad enough definition to cover it. One example, identify itself as having these powers. So I could identify myself as having these powers with respect to Bitcoin by having the private keys, right? That shows that I can avail myself of the benefits, that I can prevent others from doing so, and that I can transfer, right? Because if I have the private key that can transfer that asset, nobody else does. So that directly ties into technology as we know it now and technology in the future. There's a bunch of caveats here. They're fun read. Really, they're torture. But I would go to the UCC commentary. They give examples, and I actually find it fun. It is torturous, but it's torture.
Kathryn doesn't
fun.
like this stuff at all. I will just say that it's trying to be very medium neutral, and and it is tech driven, but trying to be open-minded about what tech could look like and not squash future development.
Yeah, exactly. And there was 2 issues that we discussed at the beginning of this presentation, which is taking free. Like, I want to know that when I get this digital asset, Sandy doesn't have like a bunch of creditors coming after her, and I'm not actually going to get that digital asset. So the new rights in these controllable electronic records include the right to take free if I have paid for it in good faith and without notice of an adverse claim. In addition, the other big pain that we were discussing about with filing and with general intangibles is the method of protecting. Here, if I can show that I have that definition of control that we talked about, then I have a perfected security interest. This is the way the market is currently acting. The drafters just tried to align the way the market thinks about it with what the rules say, so that it's easier for them to perfect their security interests in a reasonable manner. You can also do filing if that floats your boat, but control will always prevail over filing. Oh, this one's you.
Yeah.
Sorry.
So this is just so I can introduce the word tether, because people use the word tethered a lot.
And not in the technological sense, in the legal sense.
Right, in the legal sense. And that's because some digital assets are designed to carry certain rights with them, rights against other people. So for example, there can be the development of loan obligations that are embodied as a digital asset, but that show that a particular person or company owes money. Right? It's a representation that that person or company owes a payment. To whom do they owe a payment? Well, in the paper world, it's like a negotiable instrument, right? You have a payee, maybe the payee endorses it, and we have all these rules for how the person to whom the money is owed, right, is identified, series of endorsements. In regular account world, you can assign accounts. It doesn't have to be a negotiable instrument. You can assign an account, and there's a methodology for notifying the obligor on that account or payment intangible, a loan, notifying them that, hey, guess what? I assigned this. You now have to pay the other person, the new assignee. And there's lots of litigation out there where the obligor says, no, I wasn't told properly, you didn't send it to the right address, I'm not responsible. There's times when they win, there's times when they lose, because if they pay the wrong person, they have to pay twice. They're not discharged. So for this world, there was created 2 subcategories of UCC categories, a controllable account and a controllable payment intangible. Think of an account as a payment for goods sold or leased or services rendered. Think of payment intangible as like an obligation to pay back a loan. Just, paradigmatic. Is that right? Okay. Anyway, so what we had to do here that was tricky a little bit is, if I transfer control of that thing to Kathryn, how is the obligor on that loan payable going to know to pay Kathryn? So the only way you can become a controllable account or a controllable payment intangible is if internal to that asset, the obligor has agreed to pay the person who's in control in the Article 12 sense. So that way, it's kind of like an opt-in. The obligor has agreed to live with this technology and know that they are not going to make a payment until they know who is in control at that time, so that when they pay, they are discharged. But that's just one example of tethering. Whether a digital asset can drag along rights in an underlying thing, like rights to gold or even rights to land and different other things that people are developing, that's left to other law. We don't know whether a digital asset can drag the underlier unless you analyze it further. For these 2, if it's this kind of thing, it brings it, which is fun. Oh, and then we fixed a little bit the definition of money to undo the El Salvador and Central African Republic problem of making Bitcoin money. So we are going to unmake Bitcoin money for the Uniform Commercial Code. What this does not solve, of course, is the Article 9 problem, which Kathryn will get to, which was money was defined in such a way that you could only deal with it by physical possession, which obviously doesn't work. But this is one piece, changing the definition of money, so we can undo the Bitcoin issue.
Yeah, and here's the technical definition, so you can go back and look at that and have fun with that. But really what it did, just paraphrasing it, is it broke it down into electronic money and tangible money. The rules for tangible money stay the same. If you have possession of it, then you're perfected and you take it free as long as you do not act in collusion. For electronic money, we go back to that lovely definition of control yet again. First, electronic money has to be money that exists in electronic form and can be subject to control in order to benefit from this treatment. If it can, then you can perfect through control. And you can also take free, as long as you did not act in collusion. So there's lovely statutory changes, which we will not go over. I see the swipe. So you can look at these. These are just to clarify the treatment of digital assets as financial assets under Article 8. They just included some more lovely commentary to help us out.
Mostly trying to help courts get it right. So they wouldn't say something like, oh, well, there's no issuer of this digital asset, so it can't be a financial asset. Things like that. Oh, you really can't be a securities intermediary unless you're handling securities. No, the commentary is going to make clear you can live in that circle and have your own little digital asset world. All right. Oh, yes.
Choice of law, our favorite.
I love choice of law. Choice of law for transactions involving digital assets is a huge, huge international issue. Okay. The Hague Conference on Private International Law and the UNIDROIT, the Organization for the Unification of some other aspect of private international law, is they are doing a joint project for the first time in history to deal with choice of law rules applicable to digital assets. The Law Commission in London studied it for years, and it's really, really difficult to grapple with because you don't have a physical location. You don't even have an issuer sometimes. You don't even know where something's being transferred, especially if it's a decentralized system. You can't even think, oh, where's a computer node? So just to give you a taste of history and remind you that we've had digital assets for a very long time. Treasury securities and U.S. agency securities went completely uncertificated electronic decades ago. The commercial law was not ready. So the regulations treated those securities as deemed maintained in bearer definitive form, meaning like a physical bearer bond, in the possession of a Federal Reserve Bank. They thought this would be helpful because all the rules pointed to where was a physical security. And there was no physical security. Of course, it wasn't helpful that they're like a Federal Reserve Bank, so you could be like, well, is that Kansas? Is that Atlanta? Is that New York? I mean, New York is the central of the universe, so sure, of course it means New York. But that's what law had to do, like deem things to be other things because the commercial law wasn't ready. That's been solved, of course. Well, here you have a similar problem. What do? Do you deem it maintained at a particular node? How would you pick it? How would you know where it is? None of that makes any sense. So this is a very fun choice of law rule because it's so random at the end of the day. Because there's a waterfall. So the first thing you do is look to see whether the controllable electronic record itself said, I have my controllable electronic records jurisdiction. How many people think records say that? None.
It's possible.
It could.
Bitcoin has a space where you can add text to it, right? So that would be an example of saying directly on the record itself, this is the jurisdiction. Do people do that? No. Do they write, I love Bob forever on those? Yes.
They also do nefarious things, I've heard.
Do.
We don't want to talk about that. Then if they don't have that, then it's the jurisdiction specified in the controllable electronic record, the jurisdiction specified as the controllable electronic records jurisdiction in the readily available rules of the system on which the record is maintained. How many do that today? None. Okay. Then you could go to the governing law of the controllable electronic record. Right now, nobody does, because a lot of those, at least the permissionless ones, the whole idea was you were going to be
there's no contract.
Freedom of everything. You don't have to do that. Or you could go to the law specified in the readily available rules of the system. More likely in a permissioned closed system than in permissionless. Possible, but we don't know any just yet. Well, we might know a couple. Anyway, failing all that, it's the jurisdiction, it's District of Columbia. And you say, what if the District of Columbia hasn't adopted Article 12, so it has no idea what you're talking about? Then it's as if the District of Columbia adopted Article 12. What's that movie, Clueless?
Yeah.
As if. Yeah. But this is what was come up with, and that's why I say at the end of the day it's kind of random, but it's to land somewhere to make the law useful, because otherwise we would run the risk that the choice of law that the forum, when you're litigating this, decides to apply, they have no pointers. They don't know what to do with it. So that would be very sad, because we're going to love Article 12.
We are.
Okay. How many other people love Article 12?
I think we are the biggest fans. In terms of, like Sandy was just talking about, as if DC had enacted it. Has DC enacted it? No, not yet. But they have introduced a bill. Here is just a lovely little chart that shows the states that have enacted it. States are taking this up really fast. Like 2 years is unheard of to create a law this big, and it was done in 2 years. And then in terms of states adopting it, incredibly fast. I'm so sad that I do not see Pennsylvania on this list, but it's coming, guys.
In New York, we wrote a report, the Bar Association wrote a report, and so we're hopeful that New York will not, like it was in Article 8, be the 46th state to adopt. We're hoping that we're going to move faster. But the sad thing about this, and you probably realize this, is that digital assets also are quite politicized.
Yeah.
Aside from the fact that they're so tainted by fraud and other things going on, that legislatures get very skittish about moving anything forward, you then have the completely, in my humble opinion, irrational reaction of South Dakota or North Dakota or both saying, South Dakota, that was like, no, we cannot allow this change to the definition of money, because that is going to allow central bank digital currencies and that will squash private enterprise. So no, we're not doing it. No.
Does
Does
it-
this make any sense? You all look confused. No, it does not make
Does
any
it
sense.
actually create central bank digital currencies? No. It just tells you if you create a token, how to treat it so that nobody is clueless about how to treat it under the law.
Oh, let's use clueless a lot.
I think we should. Oh, cases to watch and why. Oh, I love this. Okay, really fun cases coming out. So we have some initial bankruptcy decisions that talk about custodying digital assets. We've got 2 that have come out of Celsius. They are just talking about common law custody, so not looking at cases from early 1900s. They don't actually cite them, but that's where this case law comes from, rather than there's nothing recent. So Celsius really has provided some comfort that if you kind of say to your counterparty, hey, I'll hold your digital assets and they're yours and I'm not going to do anything with them and I'll keep them safe and you have every right to them, then maybe that the courts should uphold that. Prime trust bankruptcy is going to be a really interesting one to watch. We included links because we're nerds and we want you all to be able to nerd out with us. Prime Trust has an Article 8 election, a financial asset election, in its user agreement. So if upcoming decisions in the court, Prime Trust just went into bankruptcy, but future decisions could address the Article 8 analysis that we just went through and hopefully affirm that. We will see what they do.
Yes. Hopefully
affirm it. There are no cases out there currently on that. The FTX bankruptcy is just a whole heck of a lot of fun. I have read some of it just for laughs. There's a lot of really interesting legal decisions that are coming out on digital assets in general. So if you just go to that case just to get a sense of some of the fraud that's happening in the area, which is really interesting, but also just the law and how it applies. Not on the custody or UCC aspects, but just in general, it's a riot. And then Ripple. Ripple's a really cool case because it's talking about the characterization of digital assets under U.S. securities law, which is another area that I love. And so if you can look at the Ripple case to see kind of where courts are coming out on that, there was a recent decision. It will likely be appealed, I think, is the general consensus.
They're appealing. The SEC is
the
appealing.
SEC is appealing because it wasn't completely in their favor.
Yeah, because the underlying asset was treated as not a security for federal purposes, but the package, the way it was sold, was treated as an investment contract for securities law purposes. So it was a very strange and somewhat novel to some people's minds. Full disclaimer, these are our views. Cleary's involved in the case, so I hope it comes out whatever way we're arguing, which I don't remember right at this moment. But it's going to be interesting, and it's going to make law, obviously.
But you can also just see the SEC has a huge enforcement docket right now, and you can see they are talking about things that they haven't talked about in years. Like, is this a securities exchange? Is this a broker dealer? Like, we're getting a lot of new case law in new areas, so you can poke around in their filings to get some. For those of you thinking of writing articles or notes,
Yeah, very fruitful.
Very fruitful. Oh, sorry, Sandy.
Okay. So just on the underlying, I know we're done. We have 2 minutes. On the underlying law, just so we already highlighted, we gave you the case law first so that we made sure we got to that. How are they treated in the bankruptcy of a custodian? Now, by the way, the initial days of decentralized ledger and all that, a lot of talk about disintermediation, right? We don't need intermediaries anymore. We don't need no stinking intermediaries. Yeah, right. It's distributed. But it turns out that there are benefits to using custodians. First of all, less likely you'll lose your private key. Maybe, putting aside fraud. But there are uses for that because that gives you access to markets sometimes. It gives you access to financing sometimes, use cases that we haven't even thought of yet. But a lot of people are using custodians for these assets that were supposed to maybe be treated in a decentralized manner. So what happens when, of course, fraud and mismanagement and other things occur and the custodian blows up? What's going to happen? Well, for example, under the bankruptcy code, the question would be, is this property of the estate? Because if it's property of the estate, then it's subject to all sorts of limitations, and it's not your property. It's property of the custodian. That's not what you wanted to hear, so we have to analyze what would that be. The bankruptcy code does not tell you what's property of the estate. It defers you to applicable non-bankruptcy law. So what does applicable non-bankruptcy law say? Well, as I said, if the digital assets are not property of the estate, it's yours. If they are, it's the custodian, but of course you have to find them. You have to be able to show where they are. If they are property of the estate, all sorts of bad things can happen to you. That's the why does it matter. What are the sources of applicable non-bankruptcy law? Well, one is the common law. As Kathryn mentioned, the cases that get cited here are very old, very, very old. There have been very few losses actually with bank custodians when banks go bust. Generally speaking, the custodied assets are there. For broker-dealers custodying assets, you have the Securities Investor Protection Corporation that helps cover losses which are traditionally not large. So, banks and brokers as custodians generally do not cause huge losses in the financial markets. But these new custodians are blowing up at a rare rate, and you see, fraud, because you cannot legislate around fraud. If someone's going to defraud you, you can have all the nice regulations and rules in the world, but by definition, they have, skirted them. Okay.
Another issue,
go ahead.
another main issue is that a lot of folks aren't reading the user agreements when they give their money to these organizations, and the user agreement says directly in it, you are giving us this asset, it is no longer yours.
Yeah,
So-
I can lend it, sell it, do whatever I want.
Do whatever I want with it. So folks aren't reading the agreements that they're signing up to, and that's also creating issues.
Well, so the common law, the basic common law, has all these factors for how you might determine whether someone is acting as my custodian or bailee or agent, all those concepts. How did we document it? How are we behaving? What are the rights? What rights did I give Kathryn to use my asset, if any? All that kind of stuff. You got to go through all these factors. If Kathryn starts paying me interest on the asset or something, it doesn't look like it's still my asset. Looks like I lent it to her and she's got to pay me rent on it so she can go use it, things like that.
And this is where the Celsius decisions are helpful.
Right, and they're two different programs, one of which involved interest payments, one in which involved very passive custody. So far, that came out the right way.
Yeah.
Okay, and then what I just said, because we're going to end on Article 8, because it's my favorite. If you opt into Article 8 and elect to treat your assets as financial assets, assuming you have not defrauded your customer and taken them and gotten rid of them, if you have done this, then Article 8 says clearly that unless your rule is set aside by federal law, which the Bankruptcy Code would not do, banking law would not do, Securities Investor Protection Act has a little slightly different treatment of customer property, but it's aligned. But Article 8 says the stuff is not property of the securities intermediary, it belongs to customers. And that's what you want to hear.
Yay! That was great. Okay, we're done. Oh, we didn't leave any time for questions, but we're here.
We'll be here all
And
week.
you can tell we love talking about this, so.
We'd like to encourage all of you to join us in the gallery. Just go down.
Oh, right. Questions over adult beverages.
And